What is a land trust and how it can help you? Land trusts for real estate investors, structure, use cases, and implementation. 1. Executive Overview. You evaluate land trusts as title-holding grantor trusts used by investors to manage privacy, lender sensitivity, and transfer tax exposure, while pairing them with entities for liability protection. Footnote. You frame the land trust as a narrow tool for titling and strategy rather than a standalone asset protection vehicle. 2. Core structure and parties. You form a grantor trust with 3 roles including grantor who establishes the trust, trustee who holds record title, and beneficiary who holds the economic interest and control as defined by the trust instrument. Footnote. You distinguish legal title in the trustee from beneficial ownership and control in the beneficiary. 3. Distinction from living trusts. You contrast land trusts with estate planning trusts by noting that land trusts are optimized for titling and transactional flexibility, including assignable beneficial interests, rather than probate avoidance and dispositive provisions. Footnote. You emphasize that assignability of the beneficial interest is central to land trust utility. 4. Privacy and recordation. You treat the land trust agreement as a private, unrecorded document, with only the deed to the trustee appearing in public records, thereby masking beneficiary identity and reducing targeting risk. Footnote. You rely on the separation between recorded title and private beneficial ownership to create anonymity. 5. Do on sale and acceleration sensitivity. You use the trust to reduce lender attention when ownership economics change, acknowledging that loan contracts may allow acceleration upon transfers and that limited statutory or guideline exceptions can apply, especially for transfers to certain revocable trusts when borrower status is preserved. Footnote. You treat the trust as a visibility management tool rather than a guarantee against enforcement. 6. Transfer taxes and reassessment considerations. You route property into a land trust to mitigate risk of reassessment or transfer tax where law recognizes exempt transfers, then handle beneficial interest changes privately to align with local rules and cost calculus. Footnote. You separate deed transfers that trigger public law costs from private interest assignments that may be non-recorded. 7. Title holding mechanics and nominee trustee. You place record title in a nominee trustee at inception to remove the owner's name from the chain of title while reserving operational powers to the beneficiary through the trust terms. Footnote. You allocate authority by instrument so the trustee's public presence does not imply unilateral control. 8. Trustee resignation and successor documentation. You implement immediate trustee resignation after conveyance and appoint a successor trustee in the trust, delivering a pre-signed trustee's deed to enable later record updates for refinancing or sale without disrupting privacy until needed. Footnote. You preserve anonymity day-to-day while maintaining a clean path to record authority when required. 9. Asset protection limits by jurisdiction. You recognize that, outside specific jurisdictions with protective statutes, land trusts generally do not shield beneficiaries from claims arising from the property and therefore require pairing with liability-limiting entities. Footnote. You separate privacy from protection and avoid overestimating the trust's defensive capacity. 10. Integration with limited liability companies. You assign the beneficial interest of the land trust to a limited liability company so that the LLC owns the trust and the trust holds title to the real estate, combining anonymity with liability segregation. Footnote. You stack instruments so entity shields address tort and contract exposure while the trust manages title. 11. Tax treatment and operations. You treat the land trust as a disregarded grantor trust for income tax purposes in most cases, route rents and expenses through the LLC owner of the beneficial interest, and generally avoid separate returns or employer identification numbers for the trust. Footnote. You keep tax administration simple by anchoring reporting at the LLC or owner level. 12. Subject to transactions and lender optics. You accept title into a land trust when acquiring property subject to existing financing to continue payments at the contracted rate, using the trust's private nature to limit signaling while complying with covenants and applicable law. Footnote. You manage optics and continuity of payment without asserting that obligations are waived. 13. Portfolio restructuring with minimal public filings. You deed each property from an over-concentrated LLC into its own land trust, then privately assign each trust's beneficial interest to separate LLCs, thereby reducing recorded transfers while isolating asset risk. Footnote. You convert one entity concentration into a siloed structure using trusts as transactional bridges. 14. Auctions and deployment flexibility. You take auction title in a land trust to defer the final entity decision until after closing, later assigning the beneficial interest to the appropriate LLC once financing, partners, or exit plans are settled. Footnote. You preserve post-closing optionality while keeping the investor's identity private at the courthouse. 15. Practical cautions and checklist. You verify loan terms, local transfer tax rules, and reassessment triggers, maintain trustee resignation and successor instruments, keep insurance and leases aligned with the trust LLC structure, and document assignments contemporaneously. Footnote. You operationalize the structure with compliance steps that prevent form-substance mismatches. Dash.